generally disagree with the impairment rating because it's assigned by the workers' comp doctor, who's obviously compensated by the workers' comp carrier, who ultimately sends most of their clients to that particular doctor because they tend to give lower impairment ratings and they tend to indicate that the client can return back to work, notwithstanding the serious nature of their injury. You are entitled in North Carolina to seek what's called a second opinion and get a different impairment rating. As a general rule, we see much higher impairment ratings from providers that are not biased and not impacted by the fact that they are being paid by the workers' comp carrier. And in essence, what happens is you end up averaging the workers' comp carrier's doctor and your doctor's impairment rating to generally reach a kind of a melded impairment rating. So for example, it's not uncommon for a client of ours to go and get a 10% impairment rating to the back. They would then go get a second opinion. As an example, they could get a 30% impairment rating to the back. And then what would happen is, for all intensive purposes, that rating would essentially be merged and melded, and the average would be taken, and that would probably generally be the agreed upon impairment rating, which would be 20%, obviously, given that example.